All right, guys, it's time for a little rant about the Supreme Court. Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Recato of Recato Law, a small law firm in central Minnesota, and today I gotta get something off my chest, and that's a little bit of a rant about the cowardice of the United States Supreme Court, and I mean it when I say cowardice. Their refusal to take the Texas election case is not only cowardice, it's an embarrassment to the court, and it casts severe doubt about what rule of law actually exists when there is a grievance from one state to another over the federal election, and in particular, whether or not fraud actually occurred, was occurring, whether or not the Constitution is being honored or ignored. This is pretty important, and the Supreme Court, frankly, punted on it. Now, there's also a report out there that the Supreme Court met in chambers over this case, and there could be heard screaming from Chief Justice Roberts. And at this point, even though that report is sketchy and unverified, I'm actually willing to believe it, which is sad. I shouldn't be willing to believe that John Roberts was screaming like a moron at the other justices and whining about riots influencing the court. But I can't dismiss it anymore because of the court's inaction on this topic. This is a critical juncture in American jurisprudence. We have precedent for the court stepping in on federal elections before, in particular, the court stepping in on elections of the president. And not that long ago, just 20 years ago with Bush v. Gore, the court said, we do have the authority to hear these cases. When it concerns elections of the president, we have authority to hear them. And so far, the Supreme Court has refused to even hear any of them. That does not mean that the Supreme Court would automatically rule in favor of Donald Trump and we would have Cheeto reign forever. No, that's not what anybody is suggesting or asking. All we're asking is the Supreme Court to grow a pair and step up to the damn plate. You're the only people who can do it, and hear the issues and issue a ruling on it that can actually set the parameters for how this stuff works. But instead, they didn't. They capitulated. They cried in the corner. Only two justices issued any sort of reasonable statement on it, and that was Thomas and Alito, who are not long for this world. They're both older justices. But they said that the court should at least hear the Texas case, even though in their initial assessment, they shouldn't grant the relief. And that's what we need. We have to have a court hear these types of cases, at least one of them, when we've got such serious allegations, accusations, and most importantly, the social political tension running between two halves of this country right now. We're at a tipping point, y'all. The sparks are flying, and this is a barrel full of gunpowder. And the Supreme Court, the voice of justice and reason, who says, and I quote Marbury versus Madison, we say what the law is, decided not to say what the law is at a time when we need them to the most. And why didn't they do it? Well, they dismissed it for what's called a lack of standing. Let's talk about what standing actually is, all right? Standing is a concept in federal court that says that you must have an identifiable injured party. Then you must have an identifiable party who purportedly caused the injury. Then you must be able to link directly the injury to the party that caused it. And then finally, you must have a court with the ability to redress the injury, an ability to fix it. It doesn't mean that the court will fix it, right? It just means that the court can fix it. If I come over and bust your car with a baseball bat, the court can fix that. Whether they will depend on the facts and the applicable law. Same thing with this election. So let's run through the standing argument real quick and talk about the fact that the court ignored that there was clearly standing in this case. All right? You don't have to agree that the court should have granted the remedy. You don't have to agree that the court should have said, we want to overturn the election or we need to invalidate these votes. That's a separate question, and the court had a duty to address it, and they didn't. This is the problem. But the standing argument is this. Who's hurt? Texas. How are they hurt? What's the injury? Texas says that 4 other states did not follow the constitutional process for the election. The process laid out in the elections and electors clauses of the Constitution, they didn't follow it, and therefore their capacity to select a president in this compact of states that we all agreed to peaceably be in. Remember, the states are all sovereign, individual sovereignties. They sacrifice some of their sovereign rights to the union as a whole for privileges and protections in other states, but that is predicated on an agreement that those states will abide by the same rules that everyone else does. And in this case, they said they didn't abide by the rules. They say clearly that they violated their state constitutions, their state laws, and in doing so violated the U.S. Constitution. Is that actually a U.S. constitutional violation? The only people who can actually tell us that answer definitively, punted. That's the Supreme Court. They just decided not to answer. And this is a real and serious constitutional question. And ladies and gentlemen, the peace of the republic literally is at stake. I don't know if you noticed, but there are 2 sides of this country and they're at each other's throats. We have literal violence in the street for a damn year. And the Supreme Court had the opportunity to say something, to speak to the law about this thing in some way, and they didn't. That is not acceptable. But okay, we've established that Texas is the party, and the grievance that they're saying is that other parties to the compact of states, to this union, did not honor the law of the land, which is the Constitution. They didn't follow it, and that tainted or disrupted the election. And yes, picking the executive actually matters because the executive actions will bring the states necessarily into different legal and political statuses than would be under a different executive. And this is critically important. Now, surely the federal government doesn't set state law. However, the federal government, in particular the executive branch of the federal government, is the sole organ of foreign relations, not just for the federal government, but for each state government as well. The federal government, the federal executive, can enter into executive agreements with other rulers, can enter into police actions or wars. As commander-in-chief of the military, he will draw on the citizens and residents of the various states to send them into armed global conflict if necessary. They have real implications and real concerns over who is the executive. It's why we do this in the way that we do. It's why the states send electors and why we don't have some UK style parliamentary system where a prime minister is chosen out of the legislative bodies that are represented. It's why we do the thing that we do in this way that is at the critical issue that Texas has. And again, the Supreme Court punted. This is unacceptable. All right, but who are the other parties? Well, they're other states. They're on equal footing legally with Texas. We've got Georgia, Pennsylvania, Wisconsin, and Michigan, all on the same legal statehood as Texas, and all of them, according to Texas's accusation, ignoring the constitutional mandate for how elections go. And how did they do this? They did it by administratively or executively changing, or judicially changing laws set by the legislature on how elections would be conducted. This is according to Texas. This is their grievance. And it's pretty easy on a prima facie level, or on the face of it level, to say that that's right. Now, again, Texas may be wrong. The Supreme Court may have a different interpretation of the electors and electors clauses. The Supreme Court may say that these actions don't amount to a material change to the legislative process that existed within those states. That's fine. We'll never know. They punted on the question. All right. Can the court provide redress? Yes, absolutely. The court can provide redress because the court can simply invalidate the electoral votes. Texas didn't ask them to do that. Texas asked them to go ahead and send back to their legislatures a command to legislatively choose the electors. Now, that's a great request from Texas because in doing so, the states could decide to send the exact same electors legislatively. And that would be perfectly within their rights as a state. And that goes all the way back to the beginning before we had general elections in every single state. The states would legislatively choose to send a set of electors. And we even have case law saying that when the general election wasn't acceptable, that the state could then revert and send that state chosen through the state legislature set of electors. That's perfectly acceptable to do. The Supreme Court had the power to order the states to do this or to choose not to. That's the other thing. The Supreme Court doesn't have to grant that remedy, but can they? Yes. Yes, they can. They are the arbiters of constitutional law. They say what the law is. Again, since Marbury versus Madison, and most importantly to all of this, this is within the Supreme Court's original and exclusive jurisdiction. That means that if Texas were to try and bring these grievances in any other court, that court would say, no, this belongs in the United States Supreme Court and only in the Supreme Court. They have original jurisdiction. There's no appeal process. You go straight to the Supreme Court. Just like in Monopoly, right? Don't pass go. Straight to the Supreme Court. There are no underlying steps when it's a state versus state action. And where does it say that? In the Constitution. Frankly, it's plainly in Article 3 that that's where their original jurisdiction lies. But there's even law about it. There are statutes that state that the original jurisdiction resides in the Supreme Court in matters of state versus state. And that has been interpreted as original and exclusive jurisdiction because no other forum has been granted jurisdiction over these matters. They're the only court that can hear it. It was incumbent upon them. It was their sole sacred duty to take the case and hear it. Again, the remedy is separate, and the remedy was unlikely. But abdicating their responsibility, why do you exist if you won't do your one job? The appellate jurisdiction that the Supreme Court takes, granting of cert to various cases that come up, that's actually an optional job of the court. It doesn't have to grant cert in any case. There is no legal or constitutional requirement for the Supreme Court to have appellate jurisdiction over a particular case. There is just its original jurisdictional requirements, and they didn't do it. They instead chose to do their not required job, which is unacceptable. It is unacceptable. There's nothing else. There's no other way to say it. So we have all of the arguments withstanding. We have 2 identifiable parties, well, 5 because Texas plus 4 other states, but we have an identifiable plaintiff, identifiable defendants. We have identifiable acts of the defendants that directly link to the plaintiff's injury. That is, not following their state legislature's rules are the alleged acts, and then causing injury to Texas by diluting or outright eliminating the power of their electoral votes that were cast in a purportedly constitutional way. And then we have the court having the ability to grant redress to Texas through specific orders to these states for a various, actually, there's a spectrum of possible remedies that are available to do it. for the court to issue there. That's just the one Texas requested, was that they would send an order to each of the legislatures to send a slate of electors legislatively rather than on the vote counts. Now, they didn't even explain their reasoning for lack of standing. They just said that Texas doesn't have it. Bang up job, guys, but that's not acceptable. That's not why you exist. And if the rumors are true that John Roberts was squealing like a little baby because there are riots in the streets and he didn't want to hear the case because of that, that is impeachable and he should be removed from office if that's the case. And frankly, again, based on the past, I don't know, decade of John Roberts, it's becoming increasingly easy to believe that the man is a coward who is more concerned with his personal legacy, the legacy of the Roberts Court, than he is with the rule of law. It started to be very apparent with Obamacare. It has become increasingly more apparent as the years go by and he capitulates on cases and routinely refuses to do the job of a justice of the Supreme Court and and instead referring everything to the political aspects of the legislature, the executive, or the vote. The problem, John Roberts, is that in this case, there are serious questions about the constitutionality of the vote, and you are the only group of people, 9 dying, aged, decrepit, wizened people who have the requisite knowledge and the requisite authority to determine whether or not these constitutional issues are true. And you, instead of deciding that they were true or false, simply said, we don't want to hear it. And that's unacceptable in these cases. Every other case, you can refuse to grant cert all day. You've cowarded out on guns constantly for over a decade. Our fundamental rights to guns, you have constantly refused to actually hear the cases on our fundamental rights. But that is actually within your ability to do so. This is the one time when you needed to hear a case, and it's constitutionally mandated that you should. And you decided to weasel out in the first, most efficient, and only way you could, through standing. Because the arguments that were coming about this election were really uncomfortable, and you're a coward, John Roberts. Peace, guys. Peace.